Hey everyone, Harry here to talk about the scheduling skirmishes in the Fulton County trial. So you may recall that Fani Willis came in and said, we will do this in August, which perplexed me somewhat because previously she had been really ready to go right away with all 19 defendants. There are fewer now. She seemed very eager. August, by contrast, is 9 months away from now. One interpretation is that she was looking at where other trials have staked out their schedules and wanted to sort of put in a marker that would stay. But it's problematic just because the Mar-a-Lago case, which right now is has the placeholder in April or whenever. April's the hearing on it in May, but it's quite clear that it's going to give, and a fair bit based on extensions that Eileen Cannon has given without changing yet the trial date, but it's a foregone conclusion. So what that means, her August 5th request is neither Fulton County, it seems to me, nor the Mar-a-Lago will complete before the election. So voters won't have the ability to have that information. Is he a convicted felon in these two cases going into the polls? It seems to me that's presuming, it seems likely that he's going to be the nominee. There still is the January 6th case before Judge Chutkin, scheduled for early March, and I don't think it'll give all that much. But if Willis goes on the as requested in August, and she says her trial is going to be 4 months, and that's without jury selection in a defense case, she won't finish before November 2024. And I think it will wind up that the Mar-a-Lago case trails her. So it won't even start then. So that it's quite the 1-2 punch, it seems to me. We had thought or surmised that the Mar-a-Lago case, which is a very clean case and strong one that figures to be a straight up conviction unless with short deliberation, just because the evidence is strong, unless there's some jury nullification. That's now it always seemed that maybe the judge would find a way to make that after November. Fulton County looked like a good possibility for going before. Now it looks a lot less. All right, I'm just setting the table. What happens thereafter? First, Trump came back immediately after the motion was filed and says, I oppose it. And he's going to come in and ask for an even later date. I think his claim is going to be something like Willis. This is his theory for why she puts it in August, is so that he'll have the sort of ignominy of standing for trial and showing up during the heat of the election season. At least for him, it shouldn't be going then. It will interfere so much with the campaign. Judge McAfee has shown himself, in my opinion, to be pretty level-headed, thoughtful, reasonable. So we'll see how he deals with that claim. It makes some sense, right? That, you have the home stretch of a campaign and one of the two nominees is in criminal court. Of course, everything about this is unprecedented, but that seems somewhat funky for the election and for the American people to, have a full-on campaign so they can make their judgment. All right, and that's the second thing that happened, and now the latest, John Eastman. So he's in a world of hurt. As you may recall, I've sort of conceptualized this case now, even though the pleas haven't happened, to simplify it, but I see it as Trump, Meadows, Giuliani, Eastman, Clark, and then David Schaefer, the most culpable of the Georgia elector types. Anyway, so Eastman, who's been also fighting, not successfully so far, efforts to have his disciplinary motion, or including license, taken away for his role here, comes into the court and says, I want trial sooner. Don't do August 5th, do it sooner, and make the last final guilty plea date sooner. So it's a 2-page motion. It's poorly written. It's hard to understand. It's got punctuation errors and typos, or just, it really is sloppy work by a solo practitioner, former AUSA. But, I think John Eastman is damn near broke. And he said at another time that the defense is now making him have to raid his wife's retirement fund. So I assume what's going on with this attempt to move up the trial is that I think he will wind up pleading, but he wants to be pushed one way or another sooner, just because as the months tick on, even though not that much is happening, the legal bills run up. And I really think that's what's happening to him. In a way, what's happening to Giuliani, in a way, what did happen to Chesbrough and maybe Powell, and what did happen to Ellis. It's rough stuff, that they're looking at spending so much money for a long trial because they've been charged with, everyone's kind of guilty for everything. So each of them will have to stay in with their own defenses and legal teams. And it's really expensive, and then they probably get convicted. So that's the overwhelming kind of cost-benefit calculation that I think Chesbrough, Ellis, and Powell, kind of calculated. And that's, I think, what Eastman's looking for as well. Now, it's not even a easy to understand motion, but what he seems to be saying is there's Donald Trump and there's the rest of us, 16 right now. And Trump, has to stand for election, and let's put him over. But the rest of us can go in 2 batches, and we can start before August. So he's basically, though it's very elliptical and poorly written, but he seems to be saying, let's move it all up. Let's have 2 trials, one after the other, each with 8 defendants. And then at the end of the whole thing, Trump on his own after. So one idea of this strategy here, everyone wants out of, to get away from Trump so that they can point the finger at Trump when it's tried, and so they don't have the sort of guilt by association of the most culpable actor and the like. So that's part of it, I think. And then saving money and defense costs is another part. But he's basically proffering a proposal to start earlier and have 3 different trials. That's not going to happen. It seems pretty clear to me, and the state is going to oppose that. Now, whether McAfee will go with the state's proposal of everybody as of August 5th and a final drop dead date for guilty pleas somewhat before that. And by the way, the state has said in its motion, guilty pleas by this date, and after that, we're not taking any more, and we're just going to recommend maximum sentences. So that's really designed. It's that, I think, that is going to really filter out the few defendants who remain from the big majority who plead, including most of the Georgia electors. Anyway, so we have a sentencing hearing to come where you have 3 different positions. You have the state saying August 5th already, starting a fair bit later, and based on a calendar that won't hold, Mar-a-Lago won't go before it. You have Trump saying no, who will clearly push for later, and you have Eastman now, and maybe with others, will say, let's do it earlier, and let's also move up the guilty pleas. I'm, getting bankrupt here, and also I don't want to be tried with Trump. And there's really very little in the motion, but obviously it seems to me that's what's happening. So kind of a big mess for McAfee to make sense of and resolve. I believe the hearing is set for December 1st. It's soon, and there'll be a lot of positions for him to juggle. But now John Eastman into the pool with a whole different proposal that I think basically reveals that he is running out of money and fast. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.